Hello and welcome to today's Lunch and Learn. My name is Michelle Snow. I'm Patient Education Librarian here at Princess Margaret Cancer Centre, and I will be introducing our speaker today. First, I would like to thank the Princess Margaret Cancer Foundation for providing lunch today, and also to Starbucks for providing tea and coffee. I just want to let you know that we do have some resources up at the front here, and so please help yourselves. Resources are on power of attorney and executives, and so please help yourselves to that. And you may notice that there are evaluation forms next to your seats. So if you do have an opportunity to fill in that evaluation form and hand it in either to me or to Jill sitting up at the front here, that would be great. So our speaker today is Janet Reid. And Janet Reid has over 37 years of experience in the wealth management industry and a specialized knowledge of estates and trusts. Janet has been actively focused on providing comprehensive financial management solutions to high net worth individuals and families, estates and trusts, and charitable and business organizations. Janet has demonstrated a commitment to continuous education and has earned the professional designation of Certified Financial Planner. In addition, she is a specialist at the Trust Institute, STI, a Trust and Estate Practitioner, TEP, and has completed the Canadian Securities course. Janet recently attained the Certificate in Retirement Strategy. She holds an arts degree from the University of New Brunswick. So please join me in welcoming Janet Reid.
Well, good morning, everybody. It's still morning, and it's delightful to be here with you today. I was here speaking on the same subject last year, and this subject doesn't change tremendously, but some of the stories that shape how we see the world of trust around us kind of do. So, as mentioned, my name is Janet Reid, and I've been an estate and trust advisor at TD Bank for a number of years, and I really love what I do at TD Bank. Essentially, I represent our trust offering, the Canada Trust Company, in about 30 of the retail branches around the City of Toronto. I also support our team at the private client office at St. Clair & Young, and so I deal with private bankers, with private investment counselors, and when I was young, what we called brokers, who are now private investment advisors. And I love to tell the story about trust and help our staff in the TD organization understand how we can help our clients. So today we're going to focus on estate planning. What is it all about? What are the various components of it? Why is having a will important? Why is having powers of attorney important? I want to tell you a little bit about the role of executor, because it's not an easy one, if any of you have had that duty thrust upon you, and talk to you a little bit about how, as a corporation, the Canada Trust Company, we can help you. And I do want to emphasize that every major Canadian bank, and you probably all have various relationships, we all have trust companies, and that happened a number of years ago. So all of your bank relationships, if you were to dig a little deeper, you would find they had a trust company embedded within. So what I've always felt that the trust offering, and it has been a long career with me, I've sort of gone circuitously in and out, but it really to me is all about peace of mind. So we're helping families, individuals, and typically intergenerational, their children, in difficult times. In times when people can no longer manage their money, for example, they're getting older and they either choose not to or they cannot for reasons potentially it's Alzheimer's, dementia, whatever that may be. We also help individuals when people have passed away. We help executors that are asked to take care of the estate and administer it for the beneficiaries. We can be there for any of you who find yourselves in that role. So, is that okay?
Yeah.
Nothing I said I heard.
Attention all patients and staff. Due to an IT issue with lab results, you may experience longer wait times. We thank you for your patience.
There we go. All right. So we can help in the execution phase. So if any of you find yourself power of attorney or executor for anybody you love or care about, or friends or whoever it may be, and you need help, you can always come to a trust company because you can delegate your duties, if you will. We call that an agency relationship. But we're also there in the planning phase. In my company, we have tremendous planning around high net worth estate planning, but tax planning, business succession planning, philanthropic planning. And so I would leverage off the colleagues that have these abilities. And we come up with a plan for our clients. We do a lot of sort of pre-planning. And we really emphasize that if you put some thought into your estate plan, you're going to be helping, firstly, you're going to give yourself peace of mind, but you're going to be long-term helping your family. And you're able to create a little bit of a legacy and make sure that your desires, your goals, and your values are going to live beyond the grave. So if we look at estate planning, well, what is it all about? We hear a lot about this terminology. It really, I always say, it's fluid. It's not static. Estate planning is kind of never done. The goal is to create a will and a power of attorney, but these are living documents, and we always like to say to our clients, you really should look at your will every few years to make sure that it resonates with your financial situation, with your family dynamic. So wills, I think I'm on maybe, well, I won't tell you my age, but I'm probably on will number 4 or 5. Maybe that might be excessive, but people change their wills regularly, and you must look at them when you go through situations in life. But I don't know if you guys know this, but 50% of Canadians do not have a will. And that might it seems to me like high, but the reality is I think we struggle with thinking about our own mortality. We don't want to think about the fact that we will die, and one thing we know is we all need a will. So, and I'll tell you a little bit later what happens when you don't have a will. But so 50% of us don't have a will. So is it the whole question of mortality? Is it because, we figure our children, they're not really equal, but should we treat them equally in our will? And that, I think, is a stumbling block. I have 2 sons, I was saying earlier, and they're very good friends, but they're so different. It's unbelievable. One is a creative musician type guy, terrible with money. The other one's kind of anal, he's very organized. He manages his brother's money. Now, I could think and say, well, maybe I shouldn't leave money to Terry when I pass away. Maybe it should be held in a trust, which we'll talk about later. But I'm not sure I really want to do that. And I do know his brother's in the background. But, people struggle because it's not only the difference in my children, which is slight. It's not profound. But we have a lot of issues with people with mental health issues, as you know. And what do you do as a parent around that? And also, I think when we're younger, and my kids are not infants anymore, they're in their 20s, but when you have little children, you think about, well, what if something happens to me? Because the world is rather chaotic and dreadful things happen, as we all know. And who's going to take care of those children? And people don't do their will because they're worried about the guardianship. And the irony is that you can put the guardian in your will, but the court needs to approve that. So for anyone who has little people, don't prevent it from making you do your will, because it has to go to court to approve a guardianship. So these are all things that I think, we sort of stop ourselves from getting that will done. So estate planning, it really is about, we want to preserve and grow our assets sensibly. We want to make sure that it's going to pass to the next generation in the most tax efficient way. We don't want to give us any more to the government than we have to, of course. We want to choose the appropriate executor, and that can be any of us in the room can be executors. But this trust company, the corporate executor, only trust companies can be corporate executors in your will. So something to keep in mind. We want to try to minimize the potential for family conflict. And I'm sure many of you know that when people die, people get strange. And any kind of weird family dynamic is going to emerge when people pass away. And it could be over silverware and paintings or the financials. We just never know. So we want to, estate planning, we're going to try to minimize that. But one thing I would say, when I talk to our clients, I find that the biggest thing on everybody's mind is their beneficiaries. It could be charity, where do I want to give back? But it's often if we have children, or if we have siblings, it's how do we take care of people that we worry about? And, there's so much in the media about mental health. Schizophrenia, bipolar. Individuals that suffer from this is an ongoing diagnosis, and it's not cured. With cancer, sometimes it goes into remission. These type of illnesses never do. It's ongoing. Many people that suffer from these things, they're on ongoing medication, and they might be supported to a degree by the Ontario Disability, ODSP. You've probably heard that. So there's a particular type of trust called a Henson Trust that an individual can create for a child or a relative that has one of these struggles. And it makes sure that they have the ability to go to that money as needed. They don't own it because that would affect their disability. But we call that a discretionary type of trust. So, I talk to many people. It's astounding how many people have that need. Then you have the people that have dependencies, alcohol, drugs. Recently, I met a chap who has a 21-year-old who is addicted to crack. And terrible story, but I can see he's sort of compartmentalizing it, but he wants to set up a trust for her. Then we have the spendthrift trust, and that's kind of an old term that we use in the trust industry. Might qualify for my son Terry. Money goes in one pocket and out the bottom, and he might buy another guitar and maybe a studio or something. But those are people that aren't very good with money. And sometimes people put that in trust so that they know that person will always have a flow of income. So I would say that a lot of us want to protect these people in our lives, sort of from themselves, but we want to know when we pass away that there's going to be something that they can rely on, because we really don't really know where the government's going to go with this ODSP, and it really does not help sustain a very robust life, as many of you probably know. So I really believe that if we put a lot of thought into our estate plan, there's going to be a real benefit beyond ourselves. So your will needs to take a look at, the financials, the personal, as I've been emphasizing. We need to look at changing legislation, and there's been some profound changes on the tax side to how trusts are taxed. And that's a little bit deeper, but if anyone is in a situation that you want to reach out to me, I can certainly provide more information. Legislation changes. When I was a young trust officer, I worked in Montreal, and I grew up in Quebec, and it was a civil code province. And when I started my career, the rules around matrimonial law are quite different in Quebec than they are now in Ontario. And sorry, gentlemen, but many guys would leave their assets in trust for their wives until death or remarriage. And I think the trust companies played a bigger role than they do now. I think a lot of people put the trust company as the executor and trustee. Well, that wouldn't happen today, ladies, because in Ontario, there's the Family Law Reform Act has brought in a whole different look on what matrimonial assets are. You can contract out of them if you come in via it's your second marriage. But if it's your first marriage and you're building and growing, typically your assets are joint. So, none of us could set a trust for our spouse that they only got the income. They could challenge that. So, legislation changes, and as practitioners and as people writing your will, you always have to keep that in mind. Then we look at, why do you need to have a will? And I'll give you a very sad situation that resonates, I think. My son Andy has a friend, and about 2 years ago, her father bought a business. And, fairly young guy in his 50s. I think that's fairly young. And he was excited, and Andy and he were chatting about synergies. Andy worked in a corporate sponsorship piece at a hockey team at the time. And lo and behold, the gentleman fell down the stairs in his house, and it was an unfinished basement, hit his head, and never regained consciousness. And it was pretty, it was so sudden and unexpected. But you know what? He didn't have a will. And you kind of think, the business owner, it sort of was a bit of a surprise. So he left a widow and a child. And that means in Ontario and all of Canada, if you die without a will, you're dying intestate. So basically, the government tells you how it's going to be distributed. They don't take the money, which some people think, but they say, okay, spouse gets a certain portion, child would get another portion. If there's no spouse and children, it can go up to living parents. If there's no parents, it can go to siblings. So in a time of grief, this wife and the daughter, they didn't know how things were registered. Is it joint with mom? Is it going to mom because it's joint with mom? Or is it just in dad's estate? Then you have to apply to the court to be named executor. And that's endless delay, expense, and who really needs that when you're struggling with the loss of a partner? So, it surprised me, but, again, 50% of Canadians don't have a will, and unfortunately, this chap was one of them. So why do we need a will? Well, we want to make sure that our assets are flowing according to where we want them to go. We don't want the government to say, this is how you must distribute your assets. If there are trusts that are needed, i.e. for some of younger people or not so younger people, I talk to clients whose children are in their 50s and, might have bipolar disorder, and so they're concerned. So we can set up trusts when we have a will. We can choose who our executor will be. Typically, an executor needs to be reliable, competent, But people are astounded when they're suddenly appointed executor and they didn't know. But it's good to have the choice. I can choose. I think in my case, it might be younger son who's appointed with a girlfriend at this point in time. But you can choose who you feel that would be the most appropriate person, or corporation, as I mentioned. You can leave funds to charity. And we're sitting, in Princess Margaret Hospital, which has a wonderful foundation. So the ability to, if we've been impacted by the care of the hospital in our life, we might want to leave them something. So we can choose to do that when we have a will. Whoops, I think I went the wrong way, did I? Yep, no will. So if you don't have a will, what happens? Well, we have that word intestacy. When you die without a will. So every province has intestacy rules and a formula, and they'll differ a little bit, but the gist of it is that it does not go where you want it to. I mean, what if you don't like your siblings, and we hear about that, and it ends up your assets go to your siblings, and A, they don't need it, and B, it wouldn't have been your first choice. So the intestacy rules can be quite powerful. You then have to go to the court to apply. We sometimes in the trust company meet clients where there isn't any will and the beneficiaries don't want to do the work. They ask us to go to apply to the court. You have to get kind of approval from the family members that are closest. Sometimes there are no family members. So it's time consuming. You can't take care of your family with the use of trusts. And that can be devastating if you have minor children. Because if you have minor children, do you know what happens if you have no will? Their money is actually put into the hands of the children's lawyer. And the children's lawyer can be wonderful in warring situations, but I wouldn't choose them as a money manager. So again, no ability to create trust. You can't benefit friends that are a little more distant or remote relatives because they're not going to fall into that intestacy kind of rule space. You can't benefit charities. If you have no charity, if you don't have a will, you absolutely cannot benefit charities. And whoever carries out your estate, they cannot on your behalf do that because it wasn't your intent. You did not have that in your will. So I hope that we've already illustrated that having a will is tremendously important. When you do your will, most very good drafting lawyers. So if I'm having a conversation with a client at TD Bank, I will not be drafting their will. And I'm not holding myself out as an estate planning lawyer. I'm a trust professional. So I can have a pretty robust conversation, but ultimately a lawyer will step in, an estate planning lawyer, and do your will. And if they're good, they'll make darn sure that you have powers of attorney at the same time. So we all know that we need we need the will. Ultimately, we are all going to unfortunately pass away. Powers of attorney, not necessarily. You don't necessarily need them, but you absolutely should have them. I have a 94-year-old father, and his sister's 98. These people have they live a long time. He still manages his money. I'm beginning to be very suspicious about his memory, but he has not triggered that power of attorney that I have, and he still does a lot of his stuff himself. Unless he needs to be driven around the city, which is quite frequent. However, having a power of attorney in place is important. Power of attorney in Ontario, two types. Power of attorney for property, and that's all about our financials. It's about running our houses, paying our bills, filing our tax returns, taking care of our investments. All of those financial things, power of attorney for property will cover. Power of attorney for personal care, on the other hand, is all about hygiene, nutrition, caring for yourself. And you've probably heard the term living will. In Ontario, the power of attorney for personal care often substitutes, it's not quite a living will, but most lawyers will have all sorts of directives, this health directive. What do you want to have happen if you're in a vegetative state? Do you want to be kept alive for any length of period? So these are important documents. And the failure to have one, given this is, Jill, the sad situation I'm going to mention. I was just telling Jill that one of my friends, his husband has ALS, which is Lou Gehrig's disease, and you really basically become trapped in your body, and often you don't live for more than 2 or 3 years. About 3 weeks ago, her 37-year-old brother out west, a bit of a lonely chap, very skilled, but had some sort of a bad drug experience, and he ended up, his brain, it didn't die immediately, but his brain was swollen, and it got so swollen that he ended up with no brain activity. And he did pass away naturally, 37 years old, only brother. So she has a dreadful situation going on. He had none of these documents. Now, because he did pass, him naturally after about several days in the critical care unit. But if he hadn't, the doctors, the physicians at the hospital would have been looking for who is that person who holds the personal care power of attorney. And by the failure to have it would have been a problem. Years ago, for those of us who are my age, and I don't know how many there was a situation in Florida. A woman named Terry Shivel became very big in the press, and it had to do with she ended up in a comatose situation. Her husband and her parents did not agree on how that should play out. And she didn't have any directive, no living will. It ended up going up to the Supreme Court of Florida when Jeb Bush, the former president's brother, was there. And the long short of it, she did pass away, but it was very stressful for the family members. And, you know, your religious, your spiritual beliefs play into this. So if we as individuals tell the people we love, or our closest friends and family, how we want to be treated, I personally would not want to be in a vegetative state for very long. Maybe people think differently. And that's so important for people to know. I often speak for the Alzheimer's Society, and the one thing that there's so much of this as well in our world. If you develop dementia or Alzheimer's, you cannot change any of these documents. If you didn't have them, you cannot create them. So that can be very difficult. I have a boss who's my age, and his wife has early onset Alzheimer's, and I think that they sort of planned for that. But if you don't plan for it, if you don't take the time, suddenly a spouse might not have access to the financials of their own spouse. So, you know, these are things that pre-think this, because we don't want to suddenly find ourselves in a situation where we can't create these documents. And capacity is is very important. So the ability to draft a power of attorney and a will involves a high level of capacity. In regard to the power of attorney for personal care, I just wanted to make this point. If, for example, I am power of attorney for my dad and I start to do it, my role is a fiduciary role, similar to that of an executor. And I really should do the status quo with him. He is an equity investor. He loves the stock market at 94. I wouldn't change him to a guaranteed investment certificate, low interest environment. It wouldn't be in keeping with what he did. Conversely, if he was a GIC or bond investor, I shouldn't flip him into equities. If he gave to charity, which he loves to do, I can do that because it's similar to what he did. But if he did not have a charitable bone in his body and I started giving lots of money away, that would be outside my duty to him. And actually, at the end of the day, my siblings could sue me if I made a lot of mistakes and gave a lot of money away. So the choice of powers of attorney, I just want to sort of have that resonate, is really important. You really need to trust these people. And we do hear of situations where powers of attorney don't always act in the best interests of the people they're representing. So powers of attorney are very, very important. So estate planning is really taking that in-depth look at your financials, looking at your personal situation. What are your obligations? Some people do have ongoing obligations through matrimonial situations or children that they have an ongoing obligation to. We want, as advisors in the legal community and in the trust community, we want to put you in control of your situation, making sure you're considering who you want to and would like to provide for. And we want to help you remove burden from your family and not pay too much to the CRA, which unfortunately usually comes in as a big player when we pass away. There's lots of other things that we need to consider when we're thinking about our estate. We might want to consider insurance. I'm not a big fan of insurance when you don't need it, but I'll give you a couple of examples of when you could need it. When we pass away, in a spousal situation, it usually flows to the spouse. But if we're single and we pass away, whatever we held in our hands is deemed to be disposed of by CRA, to Canada Revenue Agency. So that is if I'm an investor and I have shares of Royal Bank and I bought them at 30 and they're worth 80, there's a gain in that. So it could be a significant gain. And if you think of the 94-year-olds, and I have actually a client in one of my colleagues' books of business just passed away. She was 87. Single lady, kind of like my dad, total equity portfolio, $6 million. Can you imagine how long these people have held shares of Royal Bank? A really long time. People love to hold the banks, as you guys may know. So at date of death for those people, there's going to be a big, what we call capital gain. And the capital gain is taxed in Canada at 50% at the moment, and then according to what your marginal tax rate is. That can be a big number. My father just stubbornly says, well, I raised you, I put you through school, you can pay that bill when I die. And he means it. Some people say, I don't want my family to pay that bill. I will have some sort of an insurance piece to take care of that. So people have very different perceptions. Another time insurance can be valuable. Think of the cottage properties. So principal residence, we don't have to pay tax on that, thank goodness, especially in Toronto where the market values have skyrocketed. Think of Vancouver. But if you have a cottage property, it is not your principal residence unless you sell your city property and move to it ultimately. But you're going to have a gain in that, typically, especially in a place like Muskoka. So that's going to be a final piece on your tax return to think about. So insurance could work there. And a lot of people do that because I think cottages are really, they're assets that are very close to the heart. And many people want to make sure that their children can be able to enjoy the cottage after their death. So, insurance can be part of the discussion you have with your advisor. I talked a little bit about trust. So the trust that you have, the Henson Trust that will take care of people with difficulties like some of these mental health disorders that have ODSP. Another use of a trust, which is pretty common, is a spousal trust. And that often happens in second marriage situations. So if you think, you've got marriage number one, you have children from that marriage, and that person that maybe you're entering a second relationship with also does. But you want to honor your spouse. You have a good long marriage, so you want to honor the spouse and provide some assets to them or some flow of income to them. So you can create a trust that pays income from your assets to them in their life, but then the capital will go to your own children. And you think what could happen if you gave all your assets to your spouse and they didn't really like your children and you didn't really know it. Your children could end up with nothing from your estate. So a lot of people are really concerned about that. So a spousal trust is a good option to be able to take care of that. The other time you might want a spousal trust is if you are in a situation where you have a spouse who has Alzheimer's or dementia. And you know that if you predecease, and we know how often caregivers predecease people, your assets, rather than giving them outright to someone who can't manage them. Now, they could have a power of attorney who could take over management, but you could also do it in the way of a trust so that you choose to have maybe a trust company involved or maybe someone who you feel could manage it for the long term. So you're providing a flow of income for the spouse and all their needs, but you know that they couldn't manage it in the first place. So that's another way that a trust can be very helpful. There's a particular type of trust that you don't hear of much, but I think it's got a lot of strategic value. It's called an alter ego trust or a joint partner trust. So it's actually for people over 65. It can be done on your own or a couple. It actually takes your assets out of probate, and we'll talk a little bit more about probate later on. But you basically set your assets up in this alter ego trust or joint partner trust. Nobody can touch it in your lifetime. And you avoid probate. So if you have a significant estate, it could have some merit. I saw it played out in Etobicoke about a year ago. An older gentleman, again with Alzheimer's, 3 children, all powers of attorney together. 2 of them felt, well, we should pre-distribute Dad's assets. After all, he's not managing them. And the one son said, no, we have to make sure there's always enough flow for an older person. It got into litigation. What a surprise. And then the result was they created a trust for this gentleman, this alter ego trust. So his $2 million plus of assets were gravitated from his personal situation to a trust. The trust document was exactly like his will. So nobody was going to lose in the long term, but it protected him in the short term. And it got rid of this feuding that was going on between the family members. So I think those are all kind of interesting examples of how trust can be used in your estate plan. Some people do gifting strategies. So they might think they have way too much money for their own needs and they can gift it in their lifetime. And that does get it out of probate. I always caution people, don't gift more than you can because you just, we all probably know that healthcare can be costly as you get older. If you're living in an assisted living situation, to bring in healthcare workers can really, really kind of climb in cost. So I always caution people to be careful. But if you have significant assets, it could be an excellent strategy. And in Canada, there's no gift tax on cash. If you gift shares of Royal Bank, you would have to pay some capital gains as you gave the shares away to a child. But you do not have to worry about gifting cash. So some people use that strategy. So when we draft our wills, we have to really be sure about how our assets are registered. It's sort of one of the first things that I bring up in a conversation. Between spouses, it's typical that we're jointly registered. And that's typical. Now, it might not be in the second marriage. It might not be if someone had an operating business and they were worried about creditors or something like that. But when we register jointly with spouses, it's going to flow to the survivor outside of the will. So therefore, the will kind of becomes moot at the death of the first spouse. It avoids probate, and it avoids this capital gains. It will wait until the death of the second spouse. But I had an interesting situation that I just in the last couple of weeks, a lovely little lady who's 91, just as perky as could be, so smart. Husband of 50 years died, but she wasn't his first wife. They had no children, but he had 4 children from a previous marriage, and 2 had actually predeceased him. So his will, he left a lot of his assets joint to her, so they just will flow to her. And she's got some management people set up, and that's fine. But there's about 1.5 million that will come through his will. So he had certain assets that were registered in his own name, so they fall into the terms of his will. And he also had, I think he had an insurance policy that fell into the terms of his will. And that allowed him to pay some legacies out to his children. So in effect, he's pretty well saying, if I predecease my spouse, your stepmother, I'm going to give you some money now, but she's going to enjoy it, and then she will leave her assets to you. Now, he can't guarantee that she'll do that. Now, I think she will. I don't think at 91 she's going to run out and find a new man. You never know. But there is that risk. Once somebody owns the assets, they can pretty much, by their own will, do what they want. But I don't think she will in this case. So you've created an estate for him of a part of his assets, and a part went directly to his spouse. So keep in mind that anything that comes through your estate is going to be subject to probate, and anything that passes outside of your estate will not be. So many of us have RSPs. I don't know if anyone's a RIF age. I don't think so. But RIFs, RSPs, TFSAs, we can have named beneficiaries. And one of the beauties of that is it's not going to ever fall into your estate for the purpose of probate. What probate is in Ontario, and there's probate all across the country except for Quebec, which always, even I can say this because it's my home province, they always have to be a bit different. Probate is highest in Ontario. In a larger estate, a state that's over 100,000, it would be 1.5%. So you need to remember that those assets in your own name will go through probate. And probate, really what it does, it is a bit of a death tax to the Ontario government, but it also verifies the will. So financial organizations like TD Bank, like Royal Bank, they're not going to give away a lot of assets to the executor unless the executer has had that will probated that verifies it is indeed the last will and testament of the deceased. Because banks are always, just so you know, worried about liability. And if they gave that away and another will emerged, it could be very, very problematic. But a lot of our clients, and they come into the retail branches, and as you guys know, many people in the retail branches are very, very young. They're going through their career trajectory, and they hear them say, I want to register jointly with my children. And they're doing that to a large degree to avoid probate. And it's a problem. I believe it's a problem, because if you think about it, you hear a lot about elder abuse. People do that. They do not take care of their parents. Once you change, not everybody, many of us do, but there are the smidgen of people that don't. Once you let someone be on your registration, you're exposing yourself to what they want to do. And if they're not honorable, that could be a problem, number one. The second thing is, what if they're in a marriage and they go through a marital breakdown? Suddenly, half of your assets are exposed to a marital breakdown. That's a problem. Another problem is, what if they have a business and they go through a bankruptcy? So again, you're exposing yourself to their creditors. And one of the biggest problems, and I hope this doesn't happen very often, if my dad has a will that has 5 shares, for example, and he cleverly thinks he should register everything jointly with me because I'm his power of attorney, and he died and I wasn't very honorable, I could just say to my siblings, well, I'm sorry, but this is joint assets and it's mine. I would never do that, trust me, but some people might. So anytime you think about this joint registration, you have to think about what are the potential impacts of that. And I'm constantly telling young people in retail, no, don't just suggest that. I don't think we should be suggesting this as often as I think it goes on. And also the Ontario government has figured this out, and they know that a lot of people, well, how could you've declared all of this income on your income tax return for years, and suddenly at death there's nothing going through probate, and you don't have a spouse. So they're figuring it out, and there's going to be a lot of changes to this going forward. So be very careful if anybody talks to you about that. So just in terms, again, to reinforce, with spouses, we typically see this joint registration. So there's really a rollover of impact until the death of the second spouse. And in terms of how things are registered, a lot of very savvy people, I think, sometimes don't think about registration Last year, I was at a branch in the Beaches at Queen and Lee, and an older gal, her husband had passed away on Valentine's Day, and sadly so, long marriage. He had $3 million just in his name, and she had about another 2 just in her name. There was absolutely no need for that. This 3 had to go through probate. It all ended up in her hands. So just a misstep that someone kind of never told that gentleman along the way. Is there a specific reason you're doing this? I mean, was it to realize a desire in your will? So you don't really want that to happen. Unnecessary payment to the probate court. Estate taxes. In Canada, we don't really have them anymore. When I was young in Quebec, we had succession duties. So they've long been gone. The probate fees really, I guess, are our equivalent of estate taxes, and let's hope our government never decides to bring them back in, because, in the U.S., estate taxes are pretty powerful. And the U.S. government, the IRS, really thinks that they can have a net that goes not only of their citizens and residents, but everywhere. So, for example, if you are an investor and you have shares of Cisco or Apple, they deem that to be an asset based in the U.S. If you have a condo, another asset based in the U.S. If it's anywhere over $60,000, they're going to look at what your worldwide estate is and maybe charge you U.S. estate taxes. It's mind-boggling, but it's quite true. And we don't know, my goodness, I don't know who's following this American election, but who knows who will be president of the United States in a year. That's a little bit of a scary thought, but they could change these rules again. So it's something that we always tell our clients, and we urge them to seek some good advice from an accountant that understands U.S. estate tax. So no estates are equal. We all have different assets. We're all worth more, typically dead than alive. A lot of people now create something called a dual will strategy. So they don't have one will operating at the same time, they have 2. And this chap who left money for his second wife, he had 2 wills. Primary will and a secondary will. So some assets don't have to go through probate by their very nature. And so he had his primary will for the assets that went through probate. His secondary will had a company in it. And it was a company that really held a piece of property that was actually a Florida property that had been sold. So he saved probate on that particular asset. It was under the secondary will. People do that with operating companies. People do that with art collections. So a lot of people in this day and age have 2 wills. Got to draft that very carefully so you don't negate one will and negate the other will. So good estate planning lawyers will know how to do that. People could have operating businesses. So a lot of effort should go in, doesn't always, about what will your business succession plan be? Do you have children you want to pass it along to? How can you make sure that you're not paying too much money to the government when you could probably be more strategic? And we do have tremendous business planners at business succession planners at TD Bank that we can engage, and I'm sure every other trust company, Canadian Bank, does as well. So one of the things that I think Canadians are very focused on is charitable giving, and many of the conversations that I have with people kind of are around how they can give back. Our government has made charitable giving quite attractive. Because if you give any amount to charity, but if you give a significant amount, you're going to enjoy that tax credit in your income tax return. But if you are an investor and you have shares of, say, let's go back to Royal Bank, and you give them away, but there's a gain on those shares, you don't have to pay the capital gains tax. So it's like a double win. So it makes it very attractive to think about that. But charitable giving isn't only for the wealthy. I certainly think that we give back as Canadians. We give back with our time. We volunteer. We want to help organizations like this that have helped us and our families in our lifetime. Some of the folks in the room know that I was very excited to participate in the Enbridge Ride for the Cure for the last 2 years with my 26-year-old son, and it was really inspiring. It was also a physical challenge because we had to bike 220 kilometers over a weekend, but we did it, and it was really, really inspiring to see all the people that were so engaged and the survivors that were riding. This year, my friend whose husband has ALS is where I'm going to put my charitable effort and time. But, Canadians as a people, we're very generous. Joanne Ryan, who's our Vice President of Charitable Philanthropic Planning at TD Bank, created something about 10 years ago, I think, or 11, called the Private Giving Foundation. And for any of you who are inclined, there's a little soft copy of it over there. So any of us could set up a little foundation. Now the minimum is $10,000, so that could be daunting. But once you set that up, you can put little amounts in, $1,000, $50. You can just sort of add to it. You can add to it through your will. So it's a foundation that you, as the donor, don't have to do all the administrative work, because big foundations, that can be a lot of work. It's like an umbrella that TD does all that administrative work for you. But you can choose who your recipients are. So it could be Princess Margaret, it could be St. Michael's, it could be a combination of all sorts of charities, and then income can be paid out to them. But it's in perpetuity, which I think is really nice. You can name it what you want to name it. And like my children, in my case, could be a follow successor trustee. My dad has done this. Sorry, it was for not Princess Margaret, it was for St. Michael's. That's where I had a brother who died from cancer. So it's a really neat concept, and I do think that it can have a lot of uses. So if you want to ask anything more about that or take a look at the literature. But we're sitting in a tremendous organization, the Princess Margaret Hospital. I mean, what this hospital gives back and what they've achieved. And many of you might think that in small ways or in larger ways you'd like to contribute. And in the room today, we have the Associate Vice President of the Estate Giving, I hope that's right, Jill Nelson, who's right here.
Thank you. Janine and Catherine, who was out with the sandwiches, we all work in the Estate Giving Department of Princess Margaret. And so the one thing I want to tell you, and this applies to all charities, is if you put a charity in your will, make absolutely sure you have the correct legal name. So our correct legal name is the Princess Margaret Cancer Foundation. And then you can say, how you'd like that gift to be used if you put a gift to Princess Margaret in it. Rather than just putting Princess Margaret, which people might dispute later, we don't know what it means, Or another one that people don't always know, the Salvation Army. That their correct legal name is the Governing Council of the Salvation Army in Canada and the Bermudas. And so it saves everybody time and trouble later. If you want a gift to go to a charity, you want it to go to get the tax advantages, to make sure the gift entirely goes to the charity, and that nobody is messing around with lawyers trying to figure out who you meant. So I'll just say that, and we have a fair amount of experience with people who are leaving gifts to the Princess Margaret, and so if you wanted some advice, completely confidential and no obligation, you're welcome to call Janine or myself. So thank you, Janet.
Thank you, Jill. Tremendous, tremendous way to give your effort in time and in money if you're in a position to do so. So I did want to speak briefly about the role of an executor. Has anybody in the room been an executor? Nobody. Lucky you. It is an honor. People choose us, whoever they choose as executor, because they have a lot of respect and they trust them and they think they're competent and reliable. But it's a big job, and it's a job that involves a lot of time and carries a lot of liability. So executors can be sued by the beneficiaries if they feel the job wasn't done well. If you're executor of a house that's in a Toronto winter, not like this one, but a bad winter when someone could slip and fall, that the executor, if someone's going to sue, they're going to sue the executor. So it carries a tremendous amount of responsibility. It's what we call a fiduciary responsibility. So many of us find ourselves in the role, maybe unexpectedly. And as I mentioned when I first started to speak, you can appoint an agent to do it for you. That can be a lawyer. It can be a Canadian trust company. But you can also consider having a trust company in your will. And again, I'll say that all the major Canadian banks do have a trust presence. And so why would you want to do that? Well, the executor's role, as I say, it ranges. You have to understand the entire estate. It's a little bit like detective work. When we're in someone's will, we try to have a pretty robust idea of where they're at now. But let's face it, things are always going to change. So your financial assets, if you have real estate assets, if you have collections. Years ago, I remember there was a gun collection in an estate when I was back at Royal Trust many, many years ago. So corporate executors, typically, I'm a bit of an anomaly because I like being out and about with folks like you talking about trust. I have colleagues that love to be doing the work of running estates. It's their specialty and they're very good at it. Many of them have been in the industry for the long term, so have over 20, 30 years of experience. Colleague of mine at St. Clair is a lawyer, and she's been in the industry probably, she's my age-ish, so she's over the 35-year mark. So you've got that professionalism. These people know how to settle estate. They know all the potential pitfalls. that you've also got impartiality and objectivity. So when you're dealing with your own family dynamic, and we all think we can recover quickly from the loss of a loved one. I found it really hard to recover from the loss of my mom, and that was 8 years ago. And I think sometimes it takes your planning sort of executive brain, it gets muddled up with the sadness at losing that very important person. So the trust company, I would say, all these people bring a fair bit of compassion, because they wouldn't do this role if they didn't. But they also, they're objective. It's not their loved one. It's your loved one. So you've got that. You've got continuity. So what that means is that if I appoint someone and then I have an alternate, you should always have an alternate in your power of attorney and in your will. But that person could pass away or be unable to act for whatever reason it may be. Trust companies don't pass away. Every Canadian bank bought, merged, or organically grew. The reason was to have this ability to act as executor. And if you look at holistic financial planning in the world today, every bank needs to have a trust company presence. So we're going to be there for the long term, whether or not Janet Reid has retired in the next XYZ years. So, when is a corporation even more important? And, this lady I told you, this 87-year-old with her $6 million equity portfolio, her beneficiaries and executors are in Germany. She appointed her 80-year-old brother and her 87-year-old brother, who lives in the UK. And I chatted with the 80-year-old last Friday, and he would very much like to delegate the work to us. They will receive the assets, but the ability to do it from Germany would be kind of tough. A lot of people appoint people in the US. The US is even, as usual, the more problematic place, because US executors may have to post a bond with our government to be able to settle that estate, and that can be very expensive. So the location of an executor is something to consider. If there is a warring family dynamic, that objectivity can be important. Trusts that have to be carried on long term. Corporations can be very helpful in that, because we always have a portfolio management component. So the trust folks on one side, portfolio managers on another. Another of my little stories, a sad situation last summer, a gentleman, older chap and his son, were driving to Muskoka with their little daughter, and they had an accident outside Lake Rosso, and the father and son were killed. The little girl didn't pass away, which must have been even more traumatic for her. But grandpa's estate, so he had 3 sons. 2 of them are executors, and they did do the job. But the ongoing trust that the little girl will have until she's of age or majority, I think they will be coming to us to be able to execute that. So ongoing trust, these testamentary trusts, that can be difficult. So many times corporations can be helpful in the role of executor. So something to keep in mind when you're doing your own will, or if you are asked in the future to be executor. So just in summary, I wanted to kind of wrap up that I think that the trust offering does relieve a lot of stress for families. I think that having a will and powers of attorney in place and thoughtfully planned and looked at from time to time, of every few years, we like to say, I think that's critical. I think it's tremendous if people get on that and get it all set up, and then it removes a real burden from your mind and your shoulders. And we've talked a lot about estate planning and all the different things, and that's not an exhaustive list, because it is a complicated field and everybody's estate is unique. So I hope you have a little bit of sense of how some of this may work for your own situations, and I would be delighted to thank you for your time and attention, and delighted to answer any questions that you might have. Yes.
Great talk, Janet.
Thank you.
Lots of excellent personal stories to relate, and I could relate to some of the stories. My comment is that I do have a will, which was created 16 years ago, but I never revisit the will. So, but it's now that you talked it or you presented this, it prompted me to revisit that will.
Yeah.
My comment or question is, I have a couple old elderly parents. As you know, in Asian society, it's death and finance is taboo subjects, right? And so every time we talked about, like, to my parents, it would never get too far. So they don't divulge any information about their finances or anything like that. So, and they're getting older in life. So my question is, how do I get them to I guess approach a trust company to develop something like this, so we're not stuck. When they pass away, we're not stuck with a situation where basically
you create an intestacy on the death of the survivor. Yeah. Well, certainly, and I work up in the North York area, and there are a lot of Asian clients that I will talk to, but I understand what you're saying about the subject being a bit taboo. But if you, you might not be with TD, but if you are, I'd be delighted to meet with your parents if you'd like. Because sometimes an outsider can kind of open things up. And they I often people start like this, but then they open up a little bit more and help them understand the pressure they're going to put on their family if they don't address this. I suspect they're jointly registered, and maybe they haven't shared that with you. So the death of the first spouse can just lead to this rollover. But it's really the death of the second spouse that could be really problematic. So, if you want to, all of the trust companies, as I say, probably have people like me walking in their retail environments, and your parents probably have an allegiance to a particular bank. And any of us would be delighted to have a chat and sort of help them understand the importance of it, because the failure to do it is, give them the story of the person dying intestate and you as the children or your siblings having to apply to the court. And it costs a lot more money. So, if you can kind of just niggle them a little bit. But if you want to, I'd love to talk to them.
Thank you.